Welcome, everyone. This is Marvin Swartz from the Department of Psychiatry at Duke and the Wilson Center for Science and Justice. And thank you very much for joining us today. And the title of our panel is Not So Civil Commitment. And what we're going to do is have a presentation of by the author of the paper, Maggie Lederer, who is in her final year at Duke Law School and has written this paper. And after that, her presentation, Mark Botts from the School of Government at UNC will make a commentary, and then I will as well. If you would like to make any comments or questions, if you could put them in the Q&A section of the app, that would be very helpful. And then as we get to the time for questions and answers, I'll read them off for the discussants. So without any further ado, Ms. Lederer.
Thank you so much, Dr. Swartz. Let me try to share my screen and we can get started. Dr. Swartz, will you just let me know that you can see my screen and it's not? Okay, perfect. So I'll get started. So good afternoon, everyone. Thank you so much for being here and for your attention. As Dr. Swartz mentioned, my name is Maggie Lederer. I'm a JD student here at Duke Law in the class of 2023. Before that, I graduated from Johns Hopkins back in 2017, and I was studying psychology while I was there. And so my note that I'll give a presentation on today is called Not So Civil Commitment, and it was recently published in the Duke Law Journal. So just briefly, in this note, I survey civil commitment procedure across the states to identify its flaws. And then I propose 3 statutory reforms to increase procedural justice for those facing civil commitment. So I want to start today, as I do in my paper, with a bit of a story about a real person's experience in the civil commitment system. So one day in the fall of 2017, Mallory Green, who's a real person, but I'm using a pseudonym, was walking in Baltimore through the streets of my alma mater when a police officer spotted her. He saw her stumbling into traffic and she was almost hit by a car. So the police officer is concerned. So he brings her to a nearby hospital. To get her there, he put her in the back of his police car and drove her the short distance over. So once she gets there, doctors see that she's agitated, so they give her some emergency medication. They evaluate her and observe her, and based on that, they believe that Mallory needs inpatient care. Mallory, on the other hand, disagrees. Mallory does not want to be in a hospital, and she does not think that she needs treatment. So that leaves the hospital to begin the process of involuntary commitment. That's the process through which the state can invoke, the hospital can invoke the state's coercive power to force someone like Mallory to stay in the hospital against their will. So meanwhile, as this is happening, Mallory waits in the emergency department. The hospital psych unit is full, so they look for an available bed for her while she waits in the ER. It took 41 hours, which is nearly 2 days, for them to find a place for Mallory, which is well over Maryland's statutory limit of 30 hours. But finally, they find a bed and she's transferred to an inpatient unit. And so there, on a locked unit, Mallory waits for a chance to challenge her confinement. Under Maryland law, Mallory can wait as long as 10 days for that chance, for that judicial intervention. But finally, Mallory gets that hearing and she can challenge her confinement. Now, the hearing takes place on her site at the detaining facility, the hospital, in a conference room on her unit. Mallory sits next to a public defender that she met shortly before the hearing. And on the other side of the table, the state is represented by hospital staff. It may not even be a lawyer on the other side. And Mallory's doctor will be there too. And the doctor will testify about her diagnosis and why the doctor thinks that she's dangerous and meets the state's criteria for commitment. Now, throughout the hearing, Mallory is silent and her attorney is silent as well. The attorney does not challenge any of the hospital's testimony or presentation. Instead, at the end, the attorney makes a procedural argument. The state didn't follow the rules it should have. They allowed Mallory to wait far too long in the emergency room. They never gave her notice of this hearing or of her status as an involuntary patient. all things they are required to do by law. The judge agreed the state did not follow its own procedural rules. So what happened? Well, Mallory was still committed. The judge did not think it would be good for Mallory if she were to be discharged. And so against her will, Mallory was sent back into the hospital. So I begin with this story because I think, to me, this captures what I find troubling about civil commitment and what I found troubling when I was observing these hearings back in Baltimore when I had finished my undergrad. The outcome is not necessarily the problem. Whether Mallory and people like her belong in the hospital or whether the system or the judge got it right isn't necessarily the question or my focus. It's about the process and the procedure that put Mallory there. They don't feel fair to us, and they, perhaps most importantly, don't feel fair to people in Mallory's position. And so my paper is about how we can make this process more fair and improve it for the folks going through it. And importantly, the number of people who experience civil commitment is not small. Despite a dearth of current research here, scholars estimate that more than 1 million emergency psychiatric detentions take place every year. And in Maryland, in the year 2020 alone, nearly 10,000 civil commitment hearings happened. So this is not necessarily a small issue. And perhaps more troublingly, Mallory received more procedural process than most. The majority of hearings happen behind closed doors, and they start and end in a matter of minutes. Lawyers are passive, judges are disinterested, and they're just short hearings. So for me, in thinking about how to improve this system, I applied fundamentals of procedural justice. So what is procedural justice? Broadly speaking, procedural justice stands for the idea that people's view of an outcome of a dispute are shaped more by their view of the process and less by the outcome. So if you thought the process was fair, you're more likely to accept an outcome that is adverse to you. And we decide if a process is fair based on values like participation, dignity, and trust. So whether we were able to participate in the decision-making process, whether people listened to us, whether we were able to use our voices, whether we were treated with dignity, and whether we can trust the actors in that system. And so research has suggested, importantly, that people experiencing serious mental illness are no different. They can feel procedural justice concerns, and they can sense when they are not there. So if we can better increase procedural justice, we can improve the fairness of this system. And so just as an overview, as I will go through this presentation, I'm going to try to give a broad overview of some of the procedures and the variations by state, identify some current flaws, and then discuss a few of my proposals for reform. So it bears noting at the outset that this is an area of state law, with the exception of a handful of Supreme Court cases. The court has not really touched the issue of civil commitment, much less the procedural protections that folks like Mallory are entitled to. As a result, states largely design their own civil commitment systems, which leads to tremendous variations across the states. One advocacy group called this variation and called the United States Strategy for Serious Mental Illness as effectively running 50 different experiments with no two states taking the same approach. So given that, I will provide an overview sort of the general pathway of emergency commitment. So it bears noting that there are two big ways commitment can start. One, by submitting a petition to a court while the respondent, someone like Mallory, is still at liberty. For reasons you might imagine, that happens pretty rarely, given the nature of mental illness. It's usually time sensitive. So I will focus on the emergency route, which is much more common. And again, given the nature, there are fewer liberty protections built into that pathway. So at the beginning of this process, there is an emergency and 911 is called, or police are somehow intercept this person. Some jurisdictions use crisis teams or trained mental health professionals, but oftentimes it is police. And so they will get there, observe the individual in question, and if, based on their evaluation, they believe that psychiatric care is necessary, they'll bring the individual to the local hospital. And so I pause briefly on transport because I think that's an area of focus in this field right now. And there's a lot of discussion about replacing police interactions with individuals experiencing mental illness with more trained crisis workers. And several states have actually enacted laws that ensure folks headed for psychiatric evaluation are not transported in the same manner that criminals or suspects are. But once at a hospital, psychiatric staff will examine the individual and decide if hospitalization is necessary. During that evaluation, the person is subject to what's called an emergency hold, which is a generally short period of time in which the hospital can monitor and decide whether to initiate commitment proceedings. These are usually 72 hours, some may be more, some may be less. But at the end of this period, the hospital decides whether to go forward with commitment proceedings. Of course, at any point, the individual may decide to sign on for voluntary treatment, or the hospital may decide that the individual no longer needs commitment. So assuming that the individual does need commitment and does not consent to treatment, the next step would be the appointment of counsel. Crucially, every single state provides for the appointment of counsel in civil commitment proceedings, but that's where the commonality ends. Who counsel is, when counsel is appointed, and the duties of representation vary significantly. Just to highlight one variation, when an attorney is appointed varies. Most states require that an attorney be appointed at some point shortly after the hospital files the commitment petition, but many states take less care, either not specifying at all or just saying at some point before a hearing. And often states do not specify who the appointed counsel will be, which can lead to untrained attorneys who lack both substantive knowledge in this field and practical knowledge about how best to communicate with their clients who are often experiencing serious mental illness. And then finally, the last step is judicial involvement and the opportunity for that. I say opportunity because not all states actually provide these hearings automatically. For example, in New York provides hearings only to those individuals who ask for them themselves or have family members or attorneys who ask for them. The same goes in Colorado. And so in those states, if there's no hearing requested by the individual, commitment challenge continues largely unchallenged and unchecked by the judicial system. Luckily, most states do provide automatic hearings, so absent any waiver or extension, there will be a hearing. But the time to when these hearings happen varies dramatically. It can be as little as 72 hours to as many as 15 days. And that's just if the states are following the laws on the books. Some states have instituted a probable cause hearing in addition to full hearings. So they have an earlier preliminary hearing to see if there is probable cause to continue commitment until a later hearing. Some states don't go as far to do that, but they still have a judge review for probable cause. But in any event, if there is a hearing and when there is a full hearing, at the end, the fact finder will decide if the state's substantive criteria for commitment has been met. And if it has, the judge will enter an order of commitment. So that was a bit of a whirlwind of how emergency commitment works and an eye into some of the crucial kind of variations across the state. So with that, I'd like to hone in on some of the flaws that are particularly troublesome from a procedural justice perspective. So first, the prolonged period of detention that folks facing civil commitment wait for judicial intervention. As I mentioned, this varies tremendously, and there are some states that do not even provide hearings, so folks can wait for indefinite periods of time. Most states fall within a 5 to 7 business day range, but given that it's business days, it can end up being 7 to 9 days range. And then some states lag behind that, allowing 10 like Maryland and North Carolina, or even 15 days. Judicial hearings are crucial. It is perhaps respondents' only chance to have their voices heard on the issue of their liberty. And importantly, research suggests that people value the opportunity to present their arguments and state their views, even when they know what they are saying is having little or no influence over the decision-making process. And both the APA and the National Center for State Courts highlight the importance of a prompt hearing where folks can participate in the system. Second, I want to highlight the inadequate representation in civil commitment hearings. Often there's no specification of when an attorney should be appointed, which leaves folks confined without access to an attorney. Individuals with mental illness who are confined in psychiatric units have little access to the outside world, so are very reliant on attorneys to advocate for them. Moreover, states have largely failed to clarify what role an attorney should take within the hearing itself. So outside of civil commitment, that makes sense. You don't need to tell a lawyer how to do their job, but civil commitment is unique in that sense, and attorneys often feel the need to be paternalistic towards their client and assume that their clients who are experiencing mental illness don't necessarily know what's best for them. And so confusion arises about what standard of advocacy should apply. And this allows attorneys to refrain from the zealous advocacy that is crucial to an adversarial system. Importantly, individuals perceive adversarial processes where there are two fervently competing sides to be more fair than an inquisitorial one where sides collaborate. And so attorneys are really the mouthpieces through which their clients speak. If attorneys do not advocate for their clients' wishes are really silenced and they're not able to effectively participate in the hearing, in the system. And then finally, a big problem is non-compliance. I think one study put it well and noted that the failure of civil commitment procedures to meet statutory requirements is one of the more reliable findings in the applied social sciences. So at bottom, the actors in the system, attorneys, judges, clinical examiners, are not complying with the law. And we, as an interested community, as the legal community, have little insight into what's going on. Proceedings are often held at the detaining facility, as Mallory's was, and they're often limited to only the necessary parties. To be sure, that can have benefits, it's efficient and it's private, but it does come at a cost, and that cost is insight and information. So we need a way to monitor what's happening at these hearings if we're going to see any change. So in my note, I proposed 3 proposals designed to kind of ameliorate each of these specific flaws. I drew inspiration for these from states that are already doing these things. So these are feasible. These are current practices that states are already doing. So first, to limit the prolonged periods of detention, states should hold probable cause hearings within 72 hours of an individual's initial confinement within the hospital. Now, hearings do not need to be formal, but individuals must be present and represented by counsel. They should be given the chance to engage in dialogue and interact with the system that at least temporarily is seeking to strip them of their liberty. Now, why 72 hours? 72 hours on the one hand gives doctors an adequate window in which to stabilize the patient and potentially prepare for discharge, but it also gives both parties a chance to gather evidence in preparation for the hearing. Notably, the burden is lower in a probable cause hearing, so there's less pressure on the state to develop an evidentiary record. And on the other hand, it respects respondents' interest in immediate intervention and curtailing unwarranted deprivations of liberty. And there are several states that do this. Wyoming and New Hampshire are just a couple. To improve attorney performance, states should codify or enumerate specifically in their statutes the role and duties of counsel. So specifically, states should explain in their statutes when counsel must be appointed. And that should be as soon as a probable cause hearing is scheduled so that an attorney may prepare and meet with their client. I'll note that Wyoming is one of the few states that already does this, and they also have a 72-hour probable cause hearing in place, suggesting that it is possible to have both early appointment and early judicial intervention. States should also explicitly in their statutes require a vigorous or zealous advocate standard. Minnesota does this. That way, attorneys can no longer be confused about how to advocate in hearings, and it may alleviate some pressure that attorneys feel to act paternalistically. And hopefully codifying this duty elevates it from a ethical precept to a statutory requirement and drawing increased recognition from all players kind of in this system. And then lastly, to increase compliance with the law, I propose that states use pre-existing community-based mental health boards to oversee the commitment process. Every state already has one of these boards in place. It's actually a prerequisite to receiving certain types of federal mental health funding that all states are currently receiving. So these boards already exist. They include community stakeholders. And so they should expand their duties. And it doesn't need to be burdensome, but to include a monitoring function. So checking in if the states are holding hearings within the required period of time. How long are folks spending in the emergency department? Are attorneys meeting with their clients as they prepare? With a board in place, states and the public may begin to monitor these systems. So that was really what I set out to do in my paper. When setting out to write and publish this paper, I had 2 broad goals. First, specifically, I wanted to highlight some of the procedural failings that have troubled me in this process and propose reforms that would hopefully bring more procedural justice to the system. But beyond these reforms, I wanted to draw attention to the process of civil commitment and mental health law as a whole and spark more of a conversation, particularly in the legal space, about how our legal system treats individuals experiencing mental illness. And so with this conversation hopefully starting to grow, I think there are many areas for more research and things that I would love to look into in the future. I mean, I think as a first step, we need more insight into what is going on in these hearings. And the current empirical research, current is not the right word, but the available empirical research is dated. And so it leaves interested folks to rely on anecdotes or past experiences. So we need numbers to really know what's going on. And then there also should be more research into procedural justice and specifically how folks experiencing civil commitment, what they think of the system, how they perceive it, what changes would make this system feel most fair to them. And then finally, I think it almost goes without saying, these systems need more funding. There needs to be increased funding for state psychiatric hospitals, so there are more beds for people like Mallory, so they don't have to wait in the emergency department. If we want stronger representation, there needs to be more funding for specialized public defender services and for the courts so they can pay adequate attention to these cases. So overall, I think mental health and its intersection with the law is being talked about more. And so I'm thrilled to be here and be part of the conversation in just a small way. So with that, I will pass the baton over to Professor Botts or Dr. Swartz.
Yeah, thank you very much. That's terrific. And so our next speaker is Professor Mark Botts from the School of Government, and this is an area that he has done a lot of work on and trains stakeholders around the state in procedures in North Carolina. I just want to remind people that if you do have a question or comment, please put it in the Q&A and we'll review those as we get done with the comments. So without further ado, Professor Botts.
Thank you, Marvin. Can you hear me okay?
Yep.
Okay. So I just want to say as an introductory matter that I'm at the School of Government at the University of North Carolina. And the reason I'm on the panel is because I wanted some representation from the other side of the triangle, okay? And I want to talk about, I'm going to talk about North Carolina law and apply it to talk about how some of the things that Maggie talked about apply to North Carolina law. And in particular, the procedural justice issues of a prompt hearing and a right to counsel. If one were to read North Carolina statutes, one might conclude there is a right to a prompt hearing and a right to counsel. And indeed there are. However, if you look a little more deeply, and if you look at practice, one might conclude that actually there is the possibility and the actuality of prolonged detention without a judicial hearing, and that there is inadequate representation at a certain stage of the process. And why am I saying that? North Carolina requires that there be a hearing within 10 days of someone being taken into custody under the involuntary commitment process. Being involuntarily taken into custody, typically by a law enforcement officer, after a magistrate issues a custody and transportation order following essentially a probable cause determination. So you have a right to a hearing within 10 days of your liberty initially being deprived. The problem is that the first place you go when you're taken into custody is to a hospital emergency department or other facility-based mental health crisis center. And often people get stuck in that phase and don't move on to the next phase of the process, which is going to an inpatient facility, a 24-hour psychiatric facility, where they will be held pending a court hearing. The respondent patient only has court hearing calendared after they arrive at that 24-hour facility. They only have, the statute only provides for the appointment of counsel after they arrive at that 24-hour facility. And the problem is many people are being held indefinitely without ever arriving at that 24-hour facility, because 24-hour facilities, the inpatient psychiatric facilities around North Carolina, will say, sorry, there's no room at the end. we don't have sufficient staffing, or we don't have the beds, or this person has complicated mental health and health issues, we can't take them. So it's not unusual for someone to be held in an earlier phase of the process where there is, during that phase, no right to counsel and no access to a judicial hearing. The General Assembly is aware of this, and in fact, the General Assembly created this. This came about because there was no room at the end, people were not moving on to the 24-hour facility within 10 days, and it was hard to meet the 10-day hearing requirement if the patient's getting to the facility 1 or 2 days before the 10 days run. So the General Assembly amended the statute that says, hey, within 7 days of being taken into custody, if you can't move the person onto a 24-hour facility, you have to either discharge that person and terminate the process, or find a facility. So the process automatically terminates at 7 days, and the person is released if there is no facility available. But then some legislators, when this was being discussed in committee, said, well, wait, what if that person who we're saying has to be, as a matter of due process, released within 7 days if you can't find the facility for them, an inpatient facility? What if they're still mentally ill and dangerous to self and others? What if they still meet the inpatient commitment criteria? And so they decided, well, if that's the case, the clinician at the hospital emergency department could simply petition the magistrate again for a new custody order, which in turn would last 7 days. So you would have the due process of that probable cause determination, which is an ex parte process, and the patient's not represented by an attorney during that process. So what you can end up with, and what does happen in North Carolina, is sometimes you have a series of 7-day custody orders where a person is being deprived of their liberty, held involuntarily, in a place like an emergency department, typically, where folks there will tell you, we cannot really provide treatment for this person. That's not what we're built for. And so that I know of a case where someone sat in a hospital emergency department for 49 days. And you would go, oh my gosh, I thought there was a 10-day hearing requirement. Well, because of the feature, this particular feature of North Carolina law, and because 24 hours, there's a lack of capacity, of 24-hour facility capacity, we do in fact have people held for days, sometimes for weeks, without representation by counsel and without a judicial hearing. So that, again, that might not be readily apparent from reading the statutory law. That if you learn about the practice in North Carolina, then you can understand that that happens. So that's something I wanted to say about prompt hearings and representation. I wanted to also address, in her paper, Maggie talks about statutory reform and says, you know, statutory reform can be cumbersome and clunky, and often fails to produce its desired result. It is cumbersome and clunky. Marvin and I participated in statutory reform in North Carolina in 2017, 2018. The law was enacted in 2018, became effective 2019. What you find out when people come together for the purpose of statutory reform on many legislative issues is that it's hard to the people at the table often don't have a holistic view of the statute and don't have a holistic view of all the different interests. You often get players at the table who are representing a particular interest. I'm an attorney who works for the hospital system. I am an attorney who represents patients. And typically there's jockeying back and forth to make sure no particular stakeholder group, they're jockeying back and forth to protect their own particular interests. It's an unwieldy and time-consuming process, but there were things achieved. So let's move to the cumbersome and clunky process to, does it achieve its desired result? One of the things that Marvin and I discussed back during that period of time was the fact that in North Carolina, there's something called a psychiatric advance directive and healthcare power of attorney, which gives a patient who has a lifelong chronic, serious, and persistent mental illness the opportunity to plan for prospective situations where they lose decisional capacity. And they can give instructions to treatment providers. They can name a healthcare agent to act on their behalf. And these are tools that can be used as an alternative to involuntary commitment, in lieu of involuntary commitment. And one of the things Marvin and I discussed back then, and you'll correct me later if I'm wrong on this, Marvin, is that a lot of hospitals, a lot of the players involved in the involuntary commitment process were unaware of some of these features of North Carolina law. They were underutilized tools, psychiatric advance directives, healthcare powers of attorney. So what we did in the law was we kind of brought together different parts of the statute that talked about healthcare powers of attorney for mental health care. And we drafted 2 sections of the law and put it in the Mental Health Act, North Carolina's Mental Health Act, and we put it in the section that talks about voluntary admission to inpatient facilities, hoping to draw people's attention to it, highlight it, and make it clear that if someone ends up in the involuntary commitment process, but they happen to have a healthcare power of attorney and a healthcare agent willing to consent to their admission voluntarily, that the whole involuntary process could be avoided. The last 2 days, I've been talking with someone about a hospital in North Carolina where they seem to be either unaware of or not very well informed about the healthcare power of attorney as an alternative to involuntary commitment. So there's still, you can write things into the law, and or if it's something that they don't understand or just doesn't make sense to them, they will choose, it seems, to push that alternative aside. And that alternative was there specifically as a mechanism to reduce the need for an involuntary process at some points in time. Just checking my time here. I did want to say, with respect to community boards, Maggie talks about this in her paper, community boards and monitoring the judicial process. It would be great to have something like that in North Carolina if it could also identify some of the problems and propose solutions, recommend ways to address particular issues. And because there doesn't seem to be, I mean, people who are involuntarily committed are not a constituency that hires high-priced lawyers that can lobby the legislature for change, okay? The hospital systems have high-priced lawyers that can lobby the legislature to speak to their interests in the commitment process, okay? But not patients. So it seems to me that, and not the public in general. So it seems to me the idea of a community board would be good if it could not only monitor, but gather information and gather data. And what I would love to see is reporting requirements, different players in the process being required to report data so that we could actually identify some of the issues, what I would call problems in the involuntary commitment process. And the overall problem, there is consensus. Everyone will tell you, every law enforcement officers, magistrates, DHHS, hospitals, judges, attorneys will tell you there's lots of commitments. The judicial system is overburdened with them. There should not be so many commitments. If there was better community treatment, or if we're using commitment as a way to just get treatment in acute psychiatric situations, then maybe the commitment process is really not designed appropriately for what it's doing. So everyone talks about how it's problematic, but there's a lack of data and reporting requirements with respect to information that we can look at to actually figure out what is the basis for the things that people complain about generally? What specifically is going on? So I'll end my comments with that. And I would just say, I really enjoyed reading your article, Maggie. Good job.
Thanks very much. Great comments. And again, anybody would like to make a comment or a question, put it in the Q&A, please. So one thing that this reminded me of was that we indeed did work together on trying to tweak the involuntary commitment process some years ago. And one of the more disappointing aspects of it was that Mark and I hoped that we could get communities who are responsible for transport of involuntary commitment to rethink their use of law enforcement to transport patients, because that often results in patients being put in a police car, being put in shackles, and they do have other options and other transport opportunities. And would they rethink that? And that has been pretty disappointing so far in terms of communities getting together and rethinking their how they take custody and transportation, because that's a county level responsibility. So it was a very illuminating process to see what happened as we put things to paper, and then saw the various stakeholders with different amounts of influence metabolize those changes. Many of them survived, many didn't. One thing we hoped would be reporting of use of shackles in the transport process, which I think did not happen. But I want to just make a few comments, and then we'll get to folks who are listening. And one of the things I wanted to do is sort of contextualize this a bit more. I greatly enjoyed the paper and enjoyed working with Maggie on it and our exchanges over time. And we talked about a lot of things. But one thing I would like to say is that the context of civil commitment has massively changed over the last several decades. And whereas, you know, the changes in commitment law that led to almost the sole criterion being dangerousness to self and others, really was during a period in which that was an important civil liberties and civil rights concern. But it also was a climate in which there was an oversupply of beds. There was an abundance of beds. And one of the latent functions of those restrictive commitment criteria was to try to restrict access to beds. And that whole situation, so at the beginning of deinstitutionalization, for example, it's estimated that we had 340 public beds per 100,000 in the country. And now in North Carolina, we have 8 beds per 100,000. So and that doesn't count the changes, that doesn't count the private beds that have also been lost to the system as a result of private managed care and privatization of those agencies. So we've seen a massive retraction and constriction of beds. And one of the ironic things about that John Petrillo, a colleague, wrote about a few years ago in Psych Services, is that in effect, dangerousness has become an entitlement to a bed. And that virtually you do not get a bed, both in the private and the public sector, because the private sector has embraced commitment criteria for their pre-authorization requirement, such that the situation has flipped on its head, so that dangerousness is not restricting admission, it's the way you get admitted if you're a public patient or a patient who's either uninsured or poorly insured. And so the context of civil commitment has changed dramatically. And I would say that with Maggie's proposal, I would also propose that you bundle with it some serious looks at some of the commitment criteria. And most notably, the absence of gravely disabled criteria in most statutes. What happened, as many of you know, is we moved towards this much more restrictive type of involuntary commitment restricted to dangerousness. Most states abolished gravely disabled as a criterion, so that if you weren't dangerous, but you were just very, very sick, you no longer met criteria for involuntary admission. Now, the way North Carolina dealt with it is that they embedded grave disablement under dangerousness, which I object to because it doesn't recognize, and some of the judges I've presented to, in commitment hearings have not recognized that grave disability is in the statute. It's just under the category of dangerousness to self. And those criteria are the behavior that is grossly irrational, actions that the individual is unable to control, behavior that's grossly inappropriate to the situation, or other evidence of severely impaired judgment, insight and judgment, creates an inference that the individual is unable to care for himself. So really what you have there is a gravely disabled, or what we call a parens patriae criterion for commitment that's sort of hidden under dangerousness. And I think it would be better if we all recognize that that's a legitimate reason for admission to a hospital, and that it shouldn't be restricted just to dangerousness. The other secular change that I think is very important and maybe underscores many of Maggie's points is that when many of these procedures were developed and the criteria developed, length of stay in hospitals was typically 30 days. When I was an inpatient attending at Duke, my average length of stay was about 30 days. And so the time to first hearing had a much different context, where now the length of stay is, probably 7 days or less. And so the statutory requirement of a hearing in 10 days is very antiquated, because usually people are out of the hospital before their time for a court hearing comes up. So I think that the suggestion of a 3-day review is a good one, but I would not encumber it by a court hearing. I would suggest that you could have an independent medical review or independent review of some kind that could achieve the same purpose of making sure that that person has had a look-see at whether they should be held for a commitment hearing. And the Supreme Court actually has addressed this issue in the 70s in the case of Parent versus JR, in which they said, due process does not require that the neutral fact finder be law trained or a judicial or administrative officer, nor is it necessary that the admitting physician conduct a formal or quasi-formal adversary hearing, or that the hearing be conducted by someone other than the admitting physician. So what the Supreme Court's saying there is, you could have due process without involving the court. And I think that that would be a much more flexible way to do it, in which you had an independent review. And actually, that's how in North Carolina we resolved the issue of right to refuse treatment. That once a patient's committed, forcible administration of medication is a internal physician or independent physician review, and doesn't involve further involvement with the court and encumber the court more with something that they really don't have any more expertise than anybody else. And so I think as long as it's done forthrightly by an independent group, I think that's reasonable too. Then briefly, a couple other things. I think the lack of representation from the hospital side is a real deficit. Ideally, what the physician in a commitment hearing is doing is giving testimony about, from their examination, whether a person meets criteria or not, and that the judge then should evaluate that. But that's not really what happens, because there's no counsel to represent the hospital's interest, and what happens is that the physician and the judge usually muddle through, and it's not a good process. There ought to be representation on that side to clarify the role of the physician, clarify the role of the judge, and to have a full hearing. And then finally, the other thing I wanted to say, to echo what you're saying, is that the lack of effective counsel is really worrisome. All too often, when I had patients under commitment, the public defender would come the night before, hoping that he could get the patient to sign in the day before, usually about the 10th or the 7th day. And if the patient wouldn't sign in, the attorney would request continuance. And so in reality, very few people who opposed their commitment got a day in court within the 10-day hearing. And that just, what Mark was saying about people in the emergency room, that certainly aggravates it as well. So I think there ought to be some way for people to have effective counsel, and that counsel actually be available to represent the patient within that 10-day period. And if that extended to the emergency room, as the point that Mark pointed out, all the better. And then one final point, I think the court should be private, and transport should be avoided at all costs, because people who have not been committed, if they're outside of a state hospital has its own proceedings, it has counsel. But if you're in a place like Durham, before you're committed, you are going to be transported by law enforcement and often shackled to have your day in court. And I think that's just egregious. If you think about the children that are affected by that, or the elderly people with dementia that are affected by that, we ought to have another way to do that. And that is the position of the American Psychiatric Association, that says, these hearings should be in private. They should be as close to the patients, where the patient is at a time. And certainly with telehealth now available, we should be able to have hearings that are private, as long as that's the preference of the patient. If the patient wants a hearing, in open court, so be it. But they should be afforded that kind of privacy, in my view. So let me stop there, and again, commend Maggie for this paper. I think it's very impressive paper, and all the sourcing is very important. It is very impressive. So I hope it gets wide reading. So let me see if there's any comments. We have a comment here by Robin Huffman. There are provisions in the governor's $1 billion roadmap for behavioral health that would change transportation for IVC, and more about the intersection of mental health and justice. Heartening to read. It even suggests a review of North Carolina's IVC outpatient commitment laws, although it seems unlikely that these ideas will be adopted by the legislature. Any thoughts? Mark, do you have any comments on that? And I'll ask you, Maggie.
Yeah, I've read the proposal of the governor, which is a sort of a broad proposal that seems to invite a conversation that would get into more specifics about how to address the many issues that the governor raises in his proposal. So it's hard to say how the governor's proposal would be implemented specifically, but I think the governor, because it's not that detailed, but I think the governor does outline many different issues. And my reading of it is that it's a serious attempt to address some serious issues. It seems to me that at a minimum, it's the beginning of initiation of a conversation, and And it goes beyond IVC to deal with, you know, foster kids and DSS custody kids sitting in emergency rooms with no place to go. So there are some problems that citizens are experiencing out there. And I think the governor identifies many of them and makes some broad proposals that deserve some attention and conversation.
Yeah,
you.
I don't necessarily have much to add. I would just say I think it's exciting when politicians and anyone in government are actually talking about this. I think from my view of statutory reform, despite proposing statutory reforms, I think there are a lot of challenges to achieving that. And so I think, I mean, getting people to talk about it, if a politician is talking about it, means enough constituents care about this issue. So I think that's a positive sign. I am not necessarily holding my breath for, as Professor Botts mentioned, I'm not necessarily holding my breath to see immediately, but I think it's positive when politicians are trying to change the system and at least talking about it.
So my comment would be that, you know, we're seeing rising rates of involuntary commitment. And I think no one is innocent in that. But I think we could point a finger most pointedly at hospital systems. And I think our addiction to involuntary commitment has to do with risk aversion, that people are so concerned about risk that they've lost the focus on patient-centeredness. And I think that's, you know, Mark's anecdote about the psychiatric advance directive and healthcare power of attorney has to do with that too, is that hospitals are so concerned about their risk for something untoward happening to a patient that they're not willing to, you know, flex their procedures to try to make them more patient-centered. And I think we just need a huge culture change if we're going to move away from involuntary commitment, because it just seems to be a reflex that, for example, in the case of psychiatric advance directives, if a person lacks capacity to consent, well, that's when a psychiatric advance directive should kick in. But I think our reflex is to go to, if someone can't consent or someone lacks capacity, well, we'll involuntarily commit them. So I think we need a lot of culture change if we're really going to move away from the rising rates of involuntary commitment.
Yeah, I would just very briefly, Marvin, just say, and if anyone wants to talk about this outside of this forum, I'm happy to do so. But sort of a bottom line conclusion I have about hospitals with this particular issue raised is that hospitals complain about all the commitment respondents they have in their emergency departments. However, hospitals engage in practices that increase the number of involuntary commitment respondents being held in their facilities. So because of being risk averse with letting, and then also, and on my view, sometimes they over apply the commitment statutes. I know specifically of some anecdotal cases where they could have proceeded with voluntary admission. So
Right.
there are other issues too, but I think that there's sort of a cognitive dissonance when it comes to how we deal with people in the hospital system.
Well, and also I should say, I think physicians have become just extraordinarily risk averse too. We get, you know, lectured in and out about risk, and we've just wandered too far away from patient-centeredness and what we can do for our patients. Comment from Sarah McCartney. I agree, very impressive. Thank you much. Thank you for your passion and willingness to engage the change process for mental health issues. And she goes on to say, many students are being Baker acted when flippantly speaking of suicide by professors who've been told to be safe regarding liability. Baker Act there refers to the commitment law in Florida. Other comments?
I mean, it is a fact that there are people who seek treatment voluntarily, who are capable of giving informed consent to treatment, even to consent to the admission of a psychiatric inpatient facility. But physicians are choosing to proceed down the involuntary commitment route instead, which then calls upon the resources of the judiciary and law enforcement with transportation. And sometimes they will say, the reason I'm using the involuntary process instead of the voluntary admission process is in order to get transportation from the hospital emergency department to a 24-hour psychiatric facility. And by the way, that is not part of the standard for commitment,
Right.
that reason.
Yeah, I think that's certainly a contributing factor. And actually, one of the participants in this webinar, Sam Graberhan, is doing a 50-state survey of commitment law, looking at what the mandated role of law enforcement is in transport and custody. So hopefully we'll get that out soon. But that's been a great job.
Maggie, I wanted to, unless there's another question from the public, I wanted to ask you, Maggie, if there's,
Go ahead.
when you were looking at laws nationally, did you identify one or more states that you thought were more of a model in terms of a model to replicate in terms of procedural justice?
So what I found hard was that there were a lot of some states are doing something well, and then other states are doing poorly. Like New York, for example, does not provide a hearing automatically, but they have a specialized public defender service with largely great attorneys that are trained in mental health law, but they don't provide a hearing automatically. And then, so Wyoming is doing some things well. So I think my model would be sort of, as I did in my paper, cobbled together sort of a best practice from each state. And these are all things that states are doing. They're just not really no one has done it all together perfectly. And so I think my ideal world would be cobbling together sort of each of these practices, which to my knowledge, no state has done yet.
Interesting. And
Right,
where are you
Jim.
going after law school? Are you eventually going to be a legislator that can work on this?
We will find out. I don't know if legislation is in my future, but I'll be going back to New York. So maybe I'll fix the New York system for a bit.
Sorry to hear that North
And the New
Carolina.
York system does, yeah. And as we've talked about this, New York does have some advantages in which they have, in terms of processes, they do have attorneys that work for the state in representing clients, mental hygiene, legal services that are very professional group and have, I think, better resources to address it. In terms of that 50-state survey, there's a question about that. That's one of the things the Wilson Center at the law school is working on, and we have students and faculty working on it. I hope to get that out pretty soon. So let me thank you all again. This has been a terrific conversation, and particularly Maggie for all her tireless work on this. This is just a great piece of work. So I'm glad you shine some light on this important topic. So thanks, everybody.
Thank you.
Thank you.